My name is Chris Celentano, and I am the president of the ACS student chapter at Rutgers Newark School of Law. I am excited to introduce the moderator to the Voting Rights Institute training, Jerry Hebert. Jerry Hebert is currently the executive director and director of litigation at the Campaign Legal Center, which he joined in 2004. From 1973 to 1994, Jerry worked for the Department of Justice, where he served in many supervisory capacities, including acting chief, deputy chief, and special litigation counsel in the voting section of the Civil Rights Division. At the DOJ, Jerry also served as the chief trial counsel in over 100 voting rights lawsuits, a number of which were ultimately decided by the U.S. Supreme Court. His full bio is in your brochure, and I advise you all to read it. Without further ado, Jerry Hebert.
Thank you, Chris, and thank you to ACS and UT Law School for hosting this fabulous student convention. I'm really thrilled to be a part of it. It is ironic, as Debo said, that we would be celebrating or having this event on the 50th anniversary of the Bloody Sunday in Selma. Selma is a place very special to me. I spent many years there litigating voting rights cases, and if you're going to be in the pit, Selma is the place, is the pits in many ways. But we've made, black citizens there have made great progress in getting a piece of the pie. I'm honored that at the National Voting Rights Museum in Selma, my name is inscribed as one of the guardians of the Voting Rights Act. One of the things that I wanted to do today was to kind of give you all an overview, and I'll tell you a little bit about how we're going to proceed. It's a little different than usual. I'm going to start by giving probably a 10-minute or so, maybe longer presentation on Shelby County, setting the stage for voting rights cases today. I'm going to talk extensively about the record in the photo ID case out of Texas, because I think it's illustrative of the difficulty of litigating cases today and the burdens that we have to bear. And then I'm going to turn to Dave Richards, who's here on my right, as he was introduced last night, Cecile's father. Although I knew Dave many, many years ago and have admired his career and his groundbreaking efforts in the litigation field. Dave will talk about his experiences arguing and litigating the very first, and here's Gary Bledsoe, so come on up, Gary, take your seat up next here. Yeah, Gary is usually on time, that's true. But he calls attention to himself by coming in a couple minutes late. You're lucky Judge Costa's not here to hold you in contempt, Gary. The bios for all the panelists are on my right, but then after, Dave will talk a little bit about White v. Regester, which was the very first major vote dilution case in the Supreme Court decided in 1973, and we'll talk about what that spawned by way of progress. And then I'd like to turn to Gary and Marty, either one of you can go first, but to talk about the experiences today as litigating cases for the African American community here in Texas, and Marty in your capacity as general counsel to the Mexican American Legislative Caucus. And then we'll have Senator Wendy Davis talk about her role in the legislature and how that affects the ultimate court case, or the inevitable court case that follows, and how important that action is. And then Chad Dunn will give a wrap-up after that. During the course of each of their presentations, I will undoubtedly interrupt with questions and comments to try to flesh a little something out further. So let's talk about Shelby County. So prior to 2013, the world was pretty good, but then it got not so good. Because prior to 2013, 16 states, that's all or parts of 16 states, were subject to something known as the pre-clearance requirements. And I will say this about the pre-clearance requirements. Now, law professors generally don't make extreme statements. Now, I'm an exception to that rule, I'll confess right now. Section 5 of the Voting Rights Act was the most effective civil rights law ever enacted in the history of our country. And I'm going to explain why in a minute. because you'll see what Shelby County did and why it had such a devastating effect. Until Shelby County, any state or political subdivision in those 16 areas that I mentioned, they made any change that affected voting in any way, no matter how minor, had to undergo pre-clearance review before it could be implemented. And it was legally unenforceable unless and until it was pre-cleared. So if you saw a voting change that was being undertaken, whether it was moving a polling place, changing the entrance to a polling place, doing a redistricting plan, changing a precinct line, changing the hours for registration, the days for early voting, the locations for early voting, whatever it was, it had to undergo pre-clearance first. And it had to be shown in order to get pre-clearance that whatever you were proposing was free of a discriminatory purpose and free of a discriminatory effect. And the effect prong was interpreted by the Supreme Court to say, didn't make it worse off for minority voters. Then, the burden of proof was on the jurisdiction, the state or local government, to demonstrate that the voting change it was proposing was free of a discriminatory purpose and effect. That's huge. And then to get pre-clearance, you either had to go to DOJ in Washington, which 99.9% of all the jurisdictions did, or to a special court in Washington, D.C. Now, in Shelby County, the Supreme Court decided 5-4. It strikes down not the pre-clearance provision of Section 5, it strikes down the coverage formula that brought in those 16 states. And it did so, remembering, though, that these 16 states were originally brought in because of their long history of discrimination and the fact that they had decreased minority turnout and decreased voter registration rates. But it was declared unconstitutional. This is the part that, as a law professor, I almost burst out laughing hysterically every time I say this. But it was declared an unconstitutional violation of the Constitution's guarantee of equality among the states doctrine, which, as I recall, was only a doctrine that was applied to decide which states could be readmitted to the Union. So it seems like a stretch to me, but we'll leave that for another day. It renders pre-clearance, though, a nullity, because if nobody's subject to this coverage formula anymore, it really doesn't matter if you have pre-clearance. The Supreme Court, in its very politically wisdom, said, oh, well, Congress can just go ahead and craft a new formula. And, of course, maybe they know something we don't know about current Congress and their ability to craft anything. But it said it can devise a new formula based on, quote, current conditions. And the court said the formula that it struck down, which was based on data 40 years ago, was seriously out of date, and it didn't reflect current conditions anywhere in the country. Always nice when you see the Supreme Court litigating from up on high like that and making the determination about what's really going on in the hitherlands outside the Beltway. The last time I checked, though, I thought that Congress was the entity that was supposed to do that under the 14th and 15th Amendment, but maybe that Constitution that's in your packet, maybe they've changed the 14th and 15th Amendments without my knowing. Section 2 of the Voting Rights Act has been left intact, at least for now, until John Roberts gets his hands on that. Section 2, by the way, is the key provision of the Voting Rights Act. It is the major enforcement provision. Dave is going to talk a little bit about referencing Section 2 when he talks about White v. Register, and I'm going to prompt a couple of give and takes on that, I suspect. Now, the impact of the decision in Shelby was, at least in Texas, for example, the D.C. court, where Greg Abbott had gone to get pre-clearance of his photo ID law, that had been blocked from going into effect because a 3-judge federal court found it to be discriminatory and therefore not pre-clearable under Section 5. And that case went up on appeal. It was held on appeal until Shelby was decided, and the Supreme Court then vacated the judgment and remanded in light of Shelby, which, of course, the D.C. court then dismissed the case. One key point to think about, though, is that the D.C. court's findings of fact, they weren't vacated by the Supreme Court. The Supreme Court just vacated the judgment with respect to pre-clearance. So all the facts, which I'm going to go through in a minute, about the photo ID case that the D.C. court found, even though that can't be cited as legal precedent because the judgment was vacated, those facts are still facts. The same with respect to redistricting, which the D.C. court also had turned down. Greg Abbott announced, he tweeted right after the decision in Shelby County that, hey, the photo ID law is in effect. He did that, though, notwithstanding the fact that judgment in the D.C. court had not yet been vacated. So I thought that was a little strange for a highest law enforcement in the state to not kind of give full faith and credit to an outstanding injunction. I guess I spent not enough time on that. A few days later, Congressman Vesey filed a lawsuit in federal court because, remember, the photo ID decision in D.C., the burden of proof was on the state. Well, now with the Section 5 preclearance and nullity, we had to then go in and file a lawsuit. When I say we, I'll say full disclosure, 3 lawyers on this panel, myself, Dave Richards, and Chad Dunn, represent Congressman Vesey in that case, along with some other counsel, including Josh Bohm, who's a lawyer in my office, who's back there and helping us on the case. And we brought 4 claims. We brought a claim under Section 2 of the Voting Rights Act. We brought a purposeful discrimination claim under the 14th and 15th Amendment. Note, too, that even though Section 2 of the Voting Rights Act is a results test, you can also violate Section 2 if you prove that the discriminatory practice you're challenging was purposefully discriminatory as well. We brought something called a Crawford claim. Those of you who really are into voting rights have probably read Crawford versus Marion County, the Indiana photo ID case. I'm going to talk a little bit about that and how it differentiates from our case in Texas. And then we brought something called a very unusual challenge, a poll tax case. So Crawford versus Marion County, briefly, there's 4 things about it I want to call your attention to. And now we have people here getting CLE credit, so I'm doing a little bit more legalese than you're probably used to, but you can stand it, I think, even if you're not in your regular classrooms. So first of all, Crawford was a facial challenge seeking to have Indiana's voter ID law declared unconstitutional. And a facial challenge means it can't be applied in any circumstance, and it applies to all voters. So it's unconstitutional in all circumstances as applied to all voters. You probably have heard in law school already that usually bad cases make bad law. This is probably the best example of that you can remember, because they challenged it before it went into effect. And so therefore, it's difficult to establish, 9 nuns who have been voting for decades who suddenly are denied the right to vote by the Mother Superior, who is the poll official in Indiana, which actually happened, but after the case went up to the Supreme Court. So bringing a case, timing is everything, and when to bring it. It was a less restrictive ID law than the one in Texas. It allowed all federal and state-issued photo IDs, and if you couldn't afford one and you could sign an affidavit saying so, that you were indigent, you got to vote. That's pretty good ameliorative provision. No evidence about the number of Indiana voters who lacked ID because, again, the case was brought before the law went into effect. And there was little evidence that the voter ID law imposed significant burdens on voters who lacked ID, and little specific evidence that the voter ID failed to advance the state's asserted interest. The state's asserted interest in Indiana was that there was voter fraud to be concerned about. How many cases of voter fraud were there in Indiana that justified this law? If you said none, you would be correct. They had to actually go back to Boss Tweed as an example, Justice Stevens did, of the kind of fraud that we should all be concerned about. Our case is an as-applied challenge. We seek only relief for those Texans who lack the SB 14, which is the photo ID law, compliant IDs. We claim it's an extremely burdensome photo ID. We're trying to draw as much distinction from Indiana because it allows only certain limited forms of ID. For example, I was telling some of you students at lunch that if you are a federal FBI agent and you go to the polls to vote and you present your federal credentials, your FBI credentials with your picture on it, that's not a compliant SB 14 ID. If you're a state employee and you work in the governor's office and you show, or your attorney general's office and you show your state ID, that doesn't entitle you to vote. We presented extensive evidence, I think, that's suggesting that a large number of Texans lack an ID. I'm going to go into that. Extensive evidence about the burdens that are faced by voters that they have to overcome in order to get an ID. And then we said that it failed to advance states' asserted interest in preventing voter fraud and increasing confidence in elections. Now, Texas, when it went through this debate, said, oh, all photo ID laws are okay because Crawford said so. Well, no, that's not a correct description of what Crawford did at all. And they then said, well, we're just going to model our law after Indiana. Well, I just gave you examples of how there's no indigent provision in Texas like there was in Indiana. And in Georgia, you don't need a birth certificate to get a free ID in Georgia, but you do in Texas. You have to get a certified copy of your birth certificate, which I'm going to explain in a minute, is not free at all, the ID. And in Georgia, you can get it at any county registrar's office or driver's license office. And as Wendy Davis is going to talk about a little later, there's evidence that a number of amendments were offered to try to ameliorate SB 14 and make it more like Indiana and more like Georgia, which was being claimed by its proponents, but they were all rejected. So one of the things I think that we decided to focus on in the ID case was this. Every time that Texas made a decision about what IDs could be used, they picked an ID that was overly represented by Anglos. And every time they rejected an ID, it was one where African Americans or Latinos were disproportionately represented. So, for example, if you have a license to carry a firearm in Texas, which 90% of the people who do are Anglo, that's okay, you can have an ID, even though you don't have to be a citizen to have a license to carry. So much for the state interest that, well, we need this ID to prevent non-citizens from voting. Secondly, University of Texas IDs or any student ID is not allowed to be used. Federal and state employee IDs. And in those groups, there's evidence that at the time, Texas knew that those disproportionately helped minorities, and that's why they lopped them off as the forms of ID. Prior sessions of the legislature where ID bills had been considered and Democrats had been successful in blocking such ID requirements, in those sessions, some of these IDs were actually permitted. But then when Texas really got the supermajority to enact the law that they did in 2011, the same year they enacted intentionally discriminatory redistricting plans, that's when they took away some of the IDs that I just mentioned. And they didn't have it applied to voting by mail, so to the extent that there is any voter fraud in Texas, voter by mail in Texas is overwhelmingly, again, disproportionately used by Anglos, so it didn't apply there. And the other thing was, if you want to get a EIC, which is called an Election Information Certificate, this is a little ID that you can get that only allows you to vote. It's a picture ID, and it says to be used for voting purposes only. You can't use it for any other purpose. In order to get it, you have to get a certified copy of your birth certificate, which I'm going to talk about in a minute, is not free. But even worse, if you want to get a certified copy of your birth certificate for a reason other than getting an EIC, you can do it online or you can do it by mail. But if you want to get an EIC just for voting, you have to go down in person. So another burden, I would argue, on voters. For the first time in Texas history, DPS, a law enforcement agency, was the de facto voter registration agency because that's where you have to get the ID. And you can't vote. So the voter registration offices are largely now meaningless. You get down there and register to vote in every county, but that doesn't entitle you to cast a ballot. You've got to have a photo ID. Getting this EIC, Texas made little effort to educate people. We put on evidence about that. In fact, until trial, the DPS website contained no Spanish language information about the EIC program. And so when we had the witness on the stand for the state from the DPS office, we said, okay, let's bring up in the courtroom, let's bring up the DPS website. And they brought it up, and it was like, oh my God, it's like, don't ask a question you don't know the answer to. I thought, oh my God, what have we done? Because there's a Spanish thing right there. And then my able co-counsel, Chad Dunn, one of the others said, by the way, when did you put that Spanish button up there? Last night. Even the judge got that joke. DPS received no dedicated funding for the program, and get this, the DPS employee responsible for implementing it said he spends little time on the program and suggested that the fewer EICs his office issues, the better. Widely dispersed throughout the state, 78 of 254 counties don't even have a DPS office. Rare exceptions, open only during work hours, largely inaccessible by public transportation. They then fingerprinted and threatened to conduct warrant checks on people who applied for EICs. That might have a chilling effect. You know, if I have a speeding ticket, I'm probably not going to get down there and risk going down there. And as I say, until trial, did nothing to combat the public perception that it still fingerprints people when they come in for that. Here's some actual testimony. Let me ask a little bit about Ruby Barber. She was an Anglo woman up in the Waco area, I believe, Chad, right? And she was a woman who got an EIC without having the documents required by regulations. And we were wondering about this, how this happened. And so we called Ms. Barber and we took her deposition. And she said, well, I went down there to get it and they denied me the right to do it. And then I went and I told the local television station. And lo and behold, I got a call from the Secretary of State or DPS and they told me to go back there. So my son took me back there, so a white woman in her 80s. She goes back there and they say, well, do you have a certified copy of your birth certificate? She says, no, I was born in Tennessee. And there's no record of my birth. I was born to a midwife. And they said, well, wait a minute. Oh, yeah, we just looked and saw that the census in 1918 shows that your parents had a baby. That must be you. Okay, here's your ID. I mean, come on, really, seriously? If that woman had been black, they would have said, sorry, no ID, you're out of here. Because I'm going to show you, we put on witnesses that had that happen. She says, I didn't have documents, that's correct. We go all the way through. And we say to the DPS agent, so you moved heaven and earth to go find the census form from your birth in Tennessee, correct? He said, well, I didn't. One of our customer service agents did. Oh, that's so helpful. Thank you so much. Issuance by DPS. From June of 2013, the time of Greg Abbott's tweet, 15 months later, they issued 279 IDs, EICs. Georgia, a state less than half the size of Texas, issued 2,100 in the last half of 2006 when their photo ID went into effect. Tony Rodriguez, the senior manager at DPS, when he was told that there were 0 EICs issued, he said 0 is a good number. And then when the lack of EIC applications persisted, he wrote, this is getting better by the day. These are emails that we were able to get in discovery. And he told the director of the driver's license division who asked about these EICs, we had a close call. We almost had to issue somebody a free EIC, but that we had a clean sweep. They had issued none in those first few months. It's devastating testimony when you can get it. So, a pretext of discrimination, I call this slide. So Texas says, well, we wanted to stop in-person voter fraud. Think about in-person voter fraud. I go to the polls. I'm going to be Dave Richards, right? So I'm going to go in and I'm going to vote for Dave Richards. Now, first thing I have to hope is that the officials don't know Dave Richards. Because if they do, they know I ain't him, right? I also have to hope that they don't know me. Because if they know that I'm Jerry Hebert, they know I'm not Dave Richards. Secondly, I got to hope he hasn't already voted that day. Because if he has, and I go in trying to vote for him, they'll go, you already voted. And then, oh, that's not going to look good. And then I'm doing it in front of eyewitnesses, many of whom can ID me later as being a perpetrator. That is why you don't see voter impersonation fraud happen. There were no election outcomes shown to have changed with in-person voter fraud. There were only 2 cases in the last 14 years, despite the state's best investigation. We put on testimony from Buck Wood, a lawyer who had been like 40 years of practicing law, former director of elections in the Secretary of State's office, saying that he had never seen voter impersonation fraud and that it's easy to detect. And to the extent there is voter fraud, it's happening by mail, which photo ID laws don't have anything about. We put on Dr. Alan Lichtman. He described a proposed amendment after proposed amendment that was rejected, despite the fact that they would have racial effects. And then, of course, we put on the history of discrimination in Texas. And I always like to say, and there are great people in Texas, don't get me wrong. There are some great people in Texas. And Texas is a great state. But Texas has been discriminating for so long and in such a deep way against minority voters that they've almost lost the shame for doing so. And that's really, I think, a bad situation for many Texans who like to think of their state in a much better light. Here are the experts we had several experts. One of our experts, Dr. Heron, did a statistical analysis and found that of the millions of voters in Texas, on the roll, 619,000 lacked any of the IDs that the Texas photo ID law says. Dr. Insola Beher, the government's expert, DOJ, he said he calculated 608,000. We did a survey of Dr. Barreto and Dr. Sanchez. They came up with 516,000. And they also found that there were over 1 million eligible voters, meaning people who weren't yet registered, but they knew lacked ID and were of voting age. And then Ann McGeehan of the Secretary of State's office, who used to be in the SOS, Secretary of State's office, they had done a data match at the time they did it. They denied ever producing, having such data when legislators asked, well, have you ever done any analysis of who lacks the ID? They all said, no, I'm not informed of anything like that, but you know. Well, it turns out they did have one, and they knew that 800,000 people, according to their calculation. Always nice when you can show that somebody's got their pants on fire, to quote a 6th grade expression. So I entitled this one, this is one of Chad Dunn's favorites, Never a Good Idea to Build an Airplane While Building It. That was a quote from the head of the Department of Elections for the Secretary of State about their ability to implement the photo ID law. Doesn't sound like a safe flight to me, you know? You might want to buckle your seatbelt on that. Or better yet, maybe not get on the plane at all. It's passed in the spring of 2011. Shelby County comes down. They move to implement it within hours. And then he says it's a rocky start. They have all these problems. And they admit that the process is rocky. They announced there would be fingerprint checks for people who applied, background checks. There was misinformation on the website. The website was updated during the trial, as I said earlier. Mobile units had people, they sent mobile units out to give people ID with almost no notice to local officials. There was no signage at the DPS office for the issuance. They spent only $400,000 to implement it, and not one penny was spent to inform voters. All they did is spend money to say, hey, we now have a photo ID law in Texas. Well, I think pretty much everybody knew that already. They could have maybe spent that money telling people how to get the IDs. Georgia spent $700 grand, by the way, to ensure voter registrars in its counties could issue EICs. And if you all have cell phones, which you probably do, with a picture-taking capability, you could take pictures right there at the registrar's office and print out somebody's ID. It's about $400 to get the equipment to do that. I told you about the few number of EICs issued, the poll tax claim. So it's undisputed, and it was undisputed at trial. Oh, by the way, the Texas expert, they put on an expert. He said, I didn't do my own analysis, but I got to say, these experts on the other side, pretty much I agree with their numbers. It's always helpful. Thanks for not doing your own analysis, first of all. And then secondly, thanks for validating mine. It's always helpful. Poll tax struck down in U.S. v. Texas back in '66. Was that your case? No. The government brought that case. Here's what Texas does with getting an EIC. So if you go in to get an EIC, as I said earlier, you got to produce a certified copy of your birth certificate. $22 you have to pay. Now Texas said, well, we're going to make it free, so we're going to waive all the fees. Well, there was one fee they couldn't waive, which was a statutory fee of $2, administrative fee. Some counties made it $3. So you had to pay at least $2 or $3. But here's the thing. We put on witnesses who said, well, I'm responsible for issuing the EICs. So I come in and I say to you, I want an EIC. What do you say to me? They say, well, it's $22. I go, well, don't you tell them about the $2 discount? And they go, only if they ask. Well, that's helpful. Thanks for that, too. You know, this is just a gift that keeps on giving in this deposition. So then you go through the trial, you know, and you get people saying that, you know, well, I tried to get a birth certificate, but I don't live in Texas. I live in New Jersey. I was born in New Jersey, and it cost me $66, and I don't have $66. Texas's cross-examination of these people was to say, all right, let's go through. How much do you get in Medicaid? How much do you get Social Security? Let's add up all your income for the month, and say you get $1,800. Now let's go through your rent and your utilities and see, oh wait, you have $12 left at the end of the month. If you just waited 5 months, you'd have the $60 to send to New Jersey. And you know what the witness said? You can't eat a birth certificate. I need to eat, and my family needs to eat. Great stuff. Don't ask a question you don't know the answer to in cross-examination. You probably heard that. So, Wendy Davis offered an amendment that would have reimbursed Texans for all costs associated with getting the underlying documents to obtain an EIC. And that, like all of the other amendments she offered, failed. So Texas adopted a law that requires someone to obtain a birth certificate in order to vote. They knew that it would cost $2 to $3. They knew 25% of the Texans, according to the census, were born in other states, so they would have to pay. Texas rejected amendments to address all the concerns. We put on Ken Gandy, one of our plaintiffs, who said, I can't vote in person because I don't have the money to pay to get an ID, but he's the head election official in the Nueces County polling place where he works. But he can't vote in the polling place where he's the chief poll official. Finally, this is now your governor, used to be Greg Abbott, Attorney General. He went around the state, let me just go here. He went around the state. He said, investigating elections code violations. I'm going to train people on how to spot voter fraud. Who's committing voter fraud? I want to know, says Greg Abbott. So what does he do? These are his slides. These are his training slides. Dead people voting. The Sixth Sense, 1999. I see dead people voting. They're everywhere. They don't know they're dead. They just keep voting. 2 instances out of like 28 million Texans who voted committed impersonation fraud. So then he says, yeah, look at me. I have 3 indictments in 2005. I have these voter and fraud indictments. Hardeman County Commissioner, a Beeville woman for mail-in ballot, and another illegal ballot handling in Robstown. So first of all, none of these involved voter impersonation. But if you really want to try to convince people that there's voter fraud going on, you can't just have slides like this. You have to go over the top. And Governor Abbott now did go over the top. Here's who he said voted in person, committing voter fraud. And those are all black people. What kind of a racial cue do you think that might send? That Greg Abbott is telling people, all laws applies to voting in person, and you can commit voter fraud, and these are election code violations, so let's just show some black people all lined up to vote. So you might say, well, maybe, that was a picture they had, they got it, off Photoshop or something. So then he has another one. He says, examine documents for vote fraud. Obvious signs of tampering. So he's got a Scotch tape roll. Some handwriting on the form, different from signature. This is getting really, really mysterious, isn't it? Then, my all-time favorite, and this is a slide did you put this up in closing argument? Yeah, in the photo ID case. I put it up in the DC court. Chad put it up in Corpus Christi. But what I'm about to show you is the one that really puts it over the top. Because he says that the people who commit these voter fraud, they use unique stamps. You think it's a forever stamp? No. Sickle cell anemia. How about that? You groan just like the judges did. Just like the judges did. You can't make that up. You can't make that up. So that's who your governor is. Some people say these are racist. I'm not going to say that today. I've said it before. I'll let you make up your own mind. So, with that intro, David Richards, you've litigated tons of voting rights cases. Tell us about how you used to do it in White v. Regester, and you've come all the way to litigating new voting rights claims, even under a case called Lario v. Cox, and if you could hit that at some point. But tell us, David, about your experiences in the voting field historically.
Well, let's see. I guess what I want to start with is if you're serious about pursuing reform through litigation, you got 2 things you got to start with. Venue. You don't start cases in Indiana over discrimination against black people, because that's not where it's going on. It's going on here in Texas, and it's going on throughout the Old South. So forum selection is absolutely critical to anything you do. Some people call it forum shopping in a pejorative sense. I consider it to be the height of good lawyering. The second thing you have to know and realize, and having heard Jerry, it reinforces it, you have to have a factual, appealing case. And you can't get caught up with legal theories that somehow redound to sound as if ineluctable. The reality is, by the time you get up to an appellate court, they think they know what the law is, but they don't know beans about what the facts are. And that's what you're going to get questions about. Who shot John? And this is why when you get ready to do one of these things, or any case of reform, whether it's in voting anywhere else, have appealing facts, because that is, frankly, the linchpin of most successful litigation. White versus Regester arose after the 1970 redistricting. The Supreme Court had said in at least one case and prohibited another that at-large districts had the potential for minimizing minority voters' voting stream. And that seems self-evident if you lived in a place like I lived at the time, Dallas, Texas, which had a reputation, well-deserved reputation, for discrimination all across the board. The black population was in the 12–15% range. We had, with that census, we had 19 legislators, House members, to be elected at large. And of course, it meant that no matter what black voters did, their votes were going to be submerged and disappear in the overwhelming white electorate. So that would sort of set the stage for the litigation. And the other thing about litigation to realize is that your plans gain off to glade. So our theory was we were going to do this on a slow train. We thought we would be able to file it and get a venue in front of Wayne Justice, who was the U.S. District Judge in East Texas, to whom all civil rights cases got to, if you could. And our assumption was that we would try it as a declaratory judgment case, that is, not invoking the three-judge court principle, on the assumption it's going to take us a long time, but we could get out of Judge Justice with any luck really fact findings that would sustain us on appeal, and that was our theory. So I didn't have a plaintiff in East Texas, and I called my old friend Bill Kugel, and I said, Bill, I've got to file tomorrow, and I need a plaintiff. And he called me back, and he said, well, Dunn Register. Okay, so Dunn Register became the lead plaintiff, and to this day I've never spoken to her, and I had an occasional thought that she might not even exist, but but by that's, you know, that's my, the limitations is passed, and before I was through, I joined a lot of real people who I could find. So anyway, but it was filed, and the next day, a group of conservative Democrats who ran Dallas County politics copied my pleadings, grabbed themselves some plaintiffs, and filed a new lawsuit in Dallas, obviously trying to fix venue in Dallas County. And then that became the first battleground, which we managed to win. And then a couple other lawsuits got filed, and suddenly our declaratory judgment action became an injunction action. And so we geared up for that. I filed a lawsuit in November, early November. The judge set it for trial in 1st of January, second day or 3rd day of January. Now this is a fairly complicated case. And here we are. The redistricting panel, or legislative redistricting board, had created the plan, including the Lieutenant Governor of Texas and the Attorney General of Texas. So over the Christmas holidays, I'm taking the depositions of Lieutenant Governor Barnes and Attorney General Martin, and we have our pretrial on New Year's Day, if you can believe it. And that was, we compressed within less than 2 months this case. And we were benefited by the fact, I don't mean that the state, Leon Jaworski, who had a big reputation around, volunteered to represent the state. And the one thing you do benefit occasionally by is you have an opponent whose ego outstrips their understanding. And in this particular instance, we were benefited by that enormously because they sort of poo-pooed our case as if it were somewhere out in the hinterland. In any event, we put it on. There was then State Senator Oscar Mawsey, who had been my law partner, and he was going to try it with me, and I decided that he would be better as a witness than as a lawyer, so we took him off the pleadings, and he was an absolute student of politics in the state and was a fabulous witness, and I used him later in another case. It turns out, if you're careful with politicians, you can use them as a witness, but as a general rule, don't use them because their egos get in the way of their testimony. But
So when you get a good witness like that, do you put them on first, do you put them on last, or do you try to put them on after a bad witness?
well, we were so much by the seat of our pants in that case. I think we just put on whoever showed up kind of thing.
That's another rule.
We put in, we gathered, I can remember my old friend George Corbel was representing Maldeff in the litigation, and we put in newspaper clippings by the bale. We just put in everything, and the court just took it all. And we didn't know what we put in. The other side obviously didn't know either. But the upshot of it was we put on a pretty strong case, and the thing, though, of course, about at-large districts is that when you think about it and you do it in the context of what we call racially polarized voting, it's pretty self-evident that it has that potential for dilution of minority votes. And there were several kind of fun things. Texas had been through, as it is every decade, lengthy redistricting litigation in the 60s. And in the late 60s, they had cut Harris County, the largest county in the state, into sub-districts. And they explained to the federal court in that case that Texas had a policy that any time a county reached 1 million in population, then they would be cut into districts. Now that explanation was given to the federal court in 1968. 1971, Dallas County had 1 million people in it, and somehow that cemented state policy disappeared in smoke, never to be seen again. That was that's what you get when you litigate against Texas, frankly, this sort of hokum throughout. But in all events, we won it. The court took it. The case, I knew I had already won the case when Chief Judge Brown went to the Fifth Circuit. The three-judge court, if you probably know or don't know, configured by the judge before whom you file the case, and this is Wayne Justice. And the presiding judge of the Fifth Circuit names the other two members. Well, Chief Judge Brown named Irving Goldberg as my circuit judge on the panel, and the truth of the matter is, I say, I knew then that the handwriting was on the wall. These were the two most liberal sitting federal judges in probably in the country at that time. So I thought we were kind of like a Christian with 5 aces as we go into this thing. But we worked hard, we tried the case hard, and then we presented our proposed remedy, which was single-member districts for Dallas and Bexar County. The districts were drawn by my old friend Dan Weiser from Dallas, and he managed to figure out how to create the greatest districts imaginable. And the state, thanks to Leon Jaworski, decided they would give too much credence to our lawsuit if they presented alternative plans for our plans. The only plans presented to the court implemented it. It went up on stay. Voting litigation is essentially stay litigation. It's crazy, but it absolutely is, because it's all momentum and inertia. That is, if your case gets stayed, What the hell, you're 3 years down the line. If it doesn't get stayed, as it was in our case, we ran the elections, and by that point, it's obvious that the legislature is not going to monkey with incumbents. By the time we got them, you've already cemented them in place, basically. When we got ready to try the case, Armin Durfner, who was the guru of all voting rights at the time, was helping us. Armin was South Carolina. And he says, let's throw in a deviation claim just for the hell of it. So we threw in a deviation claim. No one even, I know, it was just lost there in the case. No one ever talked about it. It was just, you know, the classic population, one person, one vote claim. It gets to U.S. Supreme Court. No one mentions deviation. We all argue the single-member district point on all sides. The state, we had, by the way, on our side, the Republican Party of Texas at the time, represented by Tom G., who later became a Fifth Circuit judge and was a brilliant lawyer, because Republicans were in the same boat in the old one-party Texas system. They were excluded from, essentially, from politics. And we win. We lose the deviation, which we didn't care about. We win the single-member district, which was the core of the case, unanimously, almost as an aside. And the one thing I guess that should taught me, as I've learned again and again, once the case gets moving up the line, lawyers sort of control the case at the trial court level. They frame the issue and sort of are able to, once it gets in the hands of something like the U.S. Supreme Court, you're just a pawn on in their agenda. And that's, you know, sometimes good, sometimes bad, but it was in this instance. So they decided what became the core single-member district issue almost as an afterthought if you read the opinion. But of course, almost instantly after that, everywhere you turned around, there were single-member district lawsuits being filed all across the South, and many of them successful. And a serious revolution occurred in the representation of minority voters everywhere in fairly short order. White versus Regester was a 14th Amendment case. This wasn't any Voting Rights Act nonsense in that case. It was the 14th Amendment. And Congress can do what they want to do, and the court can muddle around, but the 14th Amendment still exists. And if you're going to do in the future, you're going to have to begin to think about, there's politically no replacement coming for Section 5, in my opinion. And so you're going to have to revisit the 14th Amendment cases, and they aren't all bad. Some of them are quite good. And indeed, you're talking about the Indiana voter ID case. They adopt the 14th Amendment analysis there, which is totally, you can live with, I think. And so you've got to begin to live with that. The second thing Jerry wanted me to mention was the Lario's case, which has become kind of a wild card. It's a strange one, but it's essentially a 14th Amendment case too, in the sense that when the Supreme Court decided White versus Regester, in dealing with state redistricting on the population issues, that is one person, one vote, they said we're going to cut the states some slack when they do their redistricting with respect to their own legislative bodies, House and Senate, and so if the deviation is no greater than 10%, we're going to just assume that that's okay. And that, as all things happen, when, by that we mean 5% up, 5% down, total 10% variance from the ideal. Well, of course, every legislature, and their lawyers all immediately decided that 10% was a safe harbor. The law, the 14th Amendment law, remained that you had to make a good faith effort to population equality, but the reality is what the states did, they made a good faith effort to stay within 10%. That's if you look anywhere you look, you see that going on today. In Georgia, I guess I've lost track of time. I think, that's right, 2000. There, of all things, the Democrats controlled Georgia at that time, and they redistricted their House and Senate in a purposefully discriminatory way on the basis of partisanship. That is, they stacked the deck for Democrats. And the Georgia three-judge court found that if partisanship was taint is too weak a word, I guess, infected the redistricting plan. The state lost their 10% safe harbor. And it went to the Supreme Court. They did not take the case, but they affirmed it as because it's a three-judge court case coming up, and once they take it, they got to do something with it. So they affirmed it. And so I guess that's the law as we understand it today. And I think it's explainable in the sense that the courts have grappled with partisanship or gerrymandering, and they don't like it, and they're frustrated, I think, because they've not been able to get a handle on trying to address it. And or this sort of gave them, or gives them if they want it, a handle to say, well, okay, if it's partisanship and partisan gerrymandering, then you're going to be held to the stricter standard of one person, one vote, and equality of districts. We'll see how it plays out, but I've thrown it into the current litigation of the state. And I'll leave this, people coming behind me can talk more about it, because we are litigating today, well, we're one more trough waiting for a court to act, but we're litigating the last round of redistricting in Texas. And the state has come in and said, it's non-discriminatory on the basis of race or ethnicity. It's just partisanship. We want to ensure the election of as many Republicans as possible, and hence this line is drawn this way to elect Republicans or protect Republicans. And the mere fact that that is accomplished by dividing minority communities in half and shipping them off into alien spots is not discrimination on the basis of race, but it was discrimination on the basis of party affiliation, and everybody knows that blacks and Hispanics vote Democratic. Now that issue I think, I don't know if this court's going to have the courage to deal with it. I don't know if any, but it is, the course lurks here full scale and is problematic. But the reality is that's always been what we were talking about. They didn't like the way, in my case in Dallas, they didn't like the way black people voted. So they didn't want them having any SWAT at the polls because the results they weren't going to like. And this is essentially the same damn thing, although they now labor on partisanship and think they can skate, and they perhaps can, but that's a core issue.
Thank you, David. You know, David mentioned the Supreme Court finds partisan gerrymandering distasteful, a case called Veith versus Jubilera, which was a case that I was involved in and went to the Supreme Court, another 5-4 loss. For us, the court says, you know, political gerrymandering is justiciable, but they couldn't agree on a principle that would actually define what partisan gerrymandering rose to the level of being unconstitutional. When did it become too excessive? So I always like to say that they left it justiciable, they just haven't justiced it yet. So we're kind of waiting on that. So Marty, I'd like you to talk a little bit, or if you could, about some of the issues that are facing Latinos in Texas today, including maybe referencing some of the redistricting stuff. And I'm interested if any of you have comments about Dave's last point, which is really critical, which is if the state can say that we're discriminating on the basis of partisanship because Veith gives us protection because you can't come up with a legal standard for it, then basically we can say we can discriminate to the max against blacks and Latinos because they vote Democratic. And we know they vote Democratic, and if we can just do whatever we want in terms of redistricting and maximize our partisan advantage, you're going to have a license to discriminate against blacks and Latinos. Marty?
Hi, my name is Martin Galando. Marty, please. I'm the General Counsel for the Mexican American Legislative Caucus. I want to thank you for inviting me, and it's a unique pleasure for me because there's nothing I like more than talking about voting rights. And this panel is the all-star panel. Jerry Hebert's like the Babe Ruth of voting rights, and I'm like the Forrest Gump of voting rights. So why am I here? So when you look at historical pictures and you see like LBJ signing the VRA, off to the side there's always like a staffer. There's like sitting right there. That was me for about 10 years. I was a staffer for Trey Martinez Fisher for about a decade, and Trey was the chairman of the Mexican American Legislative Caucus. And when we began this redistricting fight, and that's how I got my job, essentially. The Mexican American Legislative Caucus is a 40-member caucus of the Texas House of Representatives. It is a bipartisan caucus. There are both Democrats and Republicans as part of the caucus. It is a rural and urban and suburban caucus. It's very both politically diverse and geographically diverse. So it presents some unique redistricting problems. But Jerry's asked me here to talk about what Latinos face with voting rights changes. Let me first begin by saying voter ID requirement uniquely affects Latinos in a couple different ways. Culturally, voter ID prevents Latinos from voting because of the double name history of Latinos. My boss, Trey Martinez-Fisher, my client now, has a double name. His mother's name was Martinez and his father's name was Fisher, right? For years, his went by the name Tracy Fisher. That was his name in high school and that was his name in middle school. And when his father passed away in college, he adopted his mother's name to give honor to both of his parents. So as a consequence, is a name he adopted in order to recognize his cultural identity, a name he adopted to give honor to his father, actually could have hurt him with this law, right? Because his name is actually Ferdinand Frank Fisher III, but his adopted name is Trey Martinez Fisher, right? And that happens to all sorts of folk in all sorts of ways, all throughout Texas. And if you think about the ways in which your name differs from your official name, that happens to Latinos very often. And because of that discrepancy, there's tremendous potential to prevent people from voting. So there's that. I think the second way in which voter ID has hurt Latino turnout is that I think Latinos generally, and this is regional, they are highly responsive to voting right criticism. So if they hear rumors about people being indicted for voter fraud or people being turned away at the polls, they would prefer not just take part in that process because they feel like the process doesn't represent them. That happens a great deal. I've heard many anecdotal stories, and they're anecdotal, there's no real data behind this, but if you collect the stories and hear enough about them, that people just decide not to vote because the law itself cheapens what it means to be a Texan, if you think about it. We went from a standard where you would try to help people vote as much as you can to picking winners and losers based on what kind of ID they had. And that's why Mount got involved with the voter ID case. We decided to intervene in the initial Section 5 hearing in DC. We were represented by extraordinary counsel, one of which was Jose Garza. He's my law partner, and he would be here today but for a family emergency. So you got Forrest Gump, you didn't get the All-Star. That's the way it goes. And we also intervened in the Section 2 case in Corpus. And so let me just say, being in this room is a little strange for me. 9 years ago, I sat right where you guys were. I took Texas Civ Pro in this room, and I was mostly right there. And in fact, mostly I wasn't there. I kind of skipped class.
I can identify with that, I'm sure.
And so I bring that up to say this, is that I was a witness to history because I just got lucky, right? And all of you are about to get lucky too. Not, through hard work and graduated, but I wasn't in this class because I was at the legislature. I was working for Trey, trying to kill bills, trying to amend bills, trying to pass bills. And all of you face that same choice. I don't know what you guys are planning on doing, but you can change the world, change the state just by being present. And that's what my career is. I was just the wrong guy at the right place at the right time. And so more about Latinos. Sorry.
Marty's done more than just be present.
That's very kind. The redistricting case was a unique challenge for Malk. Malk spent about $500,000. None of it on me, but $500,000 on redistricting. And we fought it, we're still fighting it. We're still waiting at a court order. We've been fighting it for 4 years, and that includes a 2011 Section 2 trial, a 2012 Section 5 trial, another 2013 Section 2 trial, and there'll be another one, I'm sure, if we don't get it right. So it makes me cry a little bit thinking about the money. Yeah, it's been a very Byzantine process, but an enlightening one. I think when I think about the most vibrant and dynamic members, and I'm obviously biased, of the legislature today, almost all of them are MAC members. That is not a statement about ideology or political ideology. It's a statement about ability, experience, their histories, and what they do on the floor. Those are the things that matter to me. And all of them, or almost all of them, were elected from single-member districts that were created by litigation like the ones we're involved in right now. And so there's a tendency to believe that maybe litigation doesn't matter, maybe we're looking for half-of solutions, maybe we're spending too much money. But I think about the vibrant leaders of the legislature and how many of them, all of them, were elected from single-member districts. But the only reason why they had that opportunity in the first place is because of litigation like ID Redistricting and like Terrasas and lots of great civil rights cases in Texas. There was 2 Terrasas. And I think Dave was we're on both sides of them, right? Yeah. Anyways, you guys face a choice in the next couple of 4 years. What you're going to do with your lives. Do what you want, right? But there's a chance that you could do something very interesting and be a voting rights attorney. That's what I am. I'm an election law attorney. And be a witness to history and hang out with the all-stars. And so, if you have any questions about that, I'd love to talk to you about that.
Thank you, Marty. One thing that Marty mentioned was the hyphenated name issue. So where that plays out is when you go to the polls and you're a Latino and you happen to have the name Trey Martinez Fisher hyphenated, maybe your driver's license says Trey Fisher. So when you go to the polls and present your ID, they say, well, you're registered under a name here, Trey Martinez Fisher. You now, if there's a hostile poll official, they can kind of put a burden, a battle in front of you that you then have to overcome. And word gets out that poll officials are doing that, and as Marty says, maybe some people decide, I'm not going down there and suffer that embarrassment. So they don't necessarily vote. Now, if that happens, you can sign an affidavit, thanks to an amendment that was originally offered by Senator Davis. If you go and you have a mismatch in your name, your maiden name maybe is now your married name on one ID and it doesn't match the other, you can sign an affidavit simply saying you are who you claim to be as that voter. And I often wondered why, if that affidavit wasn't good enough to attest to your identity for that purpose, why shouldn't it be good enough for all purposes in voting? But for another day. One final point before I ask Gary to talk here. And Gary, bring the microphone closer to you. So I had a couple of people in the back wave to me that they want us to speak up. Dave mentioned one thing about evidence in the case, and I alluded to a number of pieces of evidence. How many, just show of hands, how many people have taken evidence? Okay, so you probably learned a lot of rules, rules of evidence and, parole evidence and hearsay and exceptions. There's only 2 rules of evidence. So I could have told you this and saved you the time. The 2 rules are this. In criminal cases, you keep it out. Civil cases, you let it in. Gary, you've represented members of Congress in redistricting litigation. You've represented African-American voters in all kinds of cases across the state of Texas. You have extensive trial experience. And I know that today African-Americans, given there's been tremendous growth of the Latino population in Texas, so much so that Texas got 4 new congressional seats. It was a little bit like, where's Waldo when we had the trial, because the 3-judge court kept saying, well, 90% of the growth in Texas was black and Latino. Where are the new seats? And Texas would say, well, there's a new seat there. And they'd say, yeah, but that's a replacement for the one you dismantled over there, so that's not new. Where are the new seats? So one of the challenges, I think, for African-American voters, and maybe you can touch on this, is that with all the Latino growth, which was the huge growth, African-Americans also grew substantially over the last decade, and Anglos did not grow at that rate. And so there's, I think, African-Americans still are underrepresented in the state across the board, and it seems like an easier demographic sell to point to Latino growth rather than African-American growth, but yet in Dallas we were able to get a new district that elected Congressman Vesey and African-American. So even though there's been tremendous Latino growth there. Latinos should also have a district in Dallas, by the way, Dallas, Tarrant County. Gary, if you would, tell us.
Sure, Jerry, thanks, and I want to say I'm really honored to be on a on a program with such great legends as Dave Richards and Jerry have done so many great things, and all on this panel. I know Senator Davis was such a great leader and kind of the floor leader on the voter ID bill when that was up, and she just did a tremendous job. And Chad has really been making a name for himself, and Marty did a great job in the redistricting battle that is still continuing, as he has mentioned. I want to apologize a little bit for being late. I was at a Board of Regents meeting. I'm a member of the Board of Regents, and I was mediating a dispute between the General Counsel and the leaders of the Faculty Senate over a proposed change and how you get tenure. So that took me a little while. I wanted to talk a little bit about the politics and then talk something about the law and some of the issues that Jerry has raised. But I wanted to take a step back so we kind of understand the dynamic that's actually taking place in the country today. Back some years back, there were some strong powers that be, very wealthy people in this country and people who run some of the multinational corporations that formed an organization, and one of the primary things that organization wanted to do was change the nature of the electorate in this country. And so you can go back and find data, internal communications involving that organization, and you can find that was an agenda item for them many years ago. And so a couple things came to their attention that I think that created somewhat of a frenzy. Number one was the election of President Barack Obama in 2008, which shocked everyone and really frightened people who are very conservative, who don't want to see minorities vote or, so to speak, turn over any kind of leadership to minorities. And you had the large influx of Latino immigrants into this country. And so, like in the trial, the redistricting trial, some of the evidence we put on related to clear bigotry, and the issues were whether you have a white state rep and they show him in bed with President Obama, they darken his skin, put a gap in his teeth or what have you to make him look a certain way, and put him with a Cadillac or a Lincoln Continental and talk about the people buying these things on welfare because of him, or they stand one next to the Mexican flag to say this is what you're voting for if you vote for this man. So they injected those kinds of things into what was occurring in Texas, and so we can understand that indeed there is a true or racial dynamic that's behind what's occurring. That's why we have the extreme redistricting proposals that we have, and that's why we have the extreme voter identification law that we have in the state of Texas, because they're trying to change, again, the nature of the electorate. Now, in the, and one of the things that we were wanting to make sure that we pointed out in the redistricting litigation was that Texas has had a history of discriminating against racial and ethnic minorities. So it doesn't really matter whether Democrats were in power or whether Republicans were in power. Because when you look way back in 1970 when Dave did White versus Regester, it was the Democrats who were discriminating against African Americans. You looked at 1980 when you had to go to court again to litigate against the state because of the redistricting plans, the Democrats were in power. 1990, Democrats were still in power. 2000, 2010, the Republicans are in power. But every single decade, when redistricting comes up, minorities have to go and file a lawsuit against the state of Texas to try to get some kind of fairness in the redistricting process. Now, let me give you one fact that I think truly looms large over what we're talking about in terms of the need to have a Voting Rights Act to protect the rights of individuals to vote, especially minorities in Texas. You heard a lot about President Obama being the first president elected that received less than 40% of the white vote as he did in 2012 when he received 39% of the vote. But the interesting thing is when you start walking through and looking at the South, he gets 9% of the white vote in Alabama. it gets 10% of the white vote in Mississippi. It gets 14% of the white vote in Louisiana. So you can see that. And in Texas, in 2008, he received 37% of the white vote, but this last time he received 26% of the white vote. So you can see that number actually diminishing, and so race is playing an even larger role. And so what's happened is the Supreme Court of the United States has been really badgered and pushed to reflect the will of the majority. And there are probably 4 votes at the Supreme Court that we'll lose every time we go. It probably doesn't really matter what the facts are or what the circumstances are. We start out 0-4 at the Supreme Court, and we've got to win all 5 of the other justices because there are 4 who are against us. So the Constitution is really under siege in many ways because of politics and money and the desire to control things and not allow people of color to share power. And Congress right now, one of the reasons why David Richards is so correct in terms of taking a look at the Constitution and the 14th Amendment to look at future litigation is that in many ways those who are somewhat reactionary or conservative like where we are. And we saw there were members, really fair members of the Republican delegation in Congress who ended up losing because the word was that they supported a fix to the Voting Rights Act because of Shelby County. And indeed, the extreme right wing has taken over, and they really are intimidating right now. They truly are intimidating reason from taking place. And so it's going to be unlikely that we see the kind of fix that we'd like to see to the Voting Rights Act, if any fix at all. Now, one of the things that's kind of missing from the quotient is we don't have a national movement or groundswell of opposition saying that we need a fix to Shelby County. Because we just basically have the lawyers talking to Congress folks, and so there's no momentum. You know, what LBJ told Martin Luther King was that you need to go out there and make me pass this law. And that's what needs to happen. It's important to have the commemorations that we're having like in Selma today and tomorrow. But I think right now the Voting Rights Act is not what it should be. And in fact, a hole has been shot in it with a double-barreled shotgun. And we need to see what we can do to repair it because we can have the forms that we need to be able to litigate effectively. Now in Texas, one of the dynamics that Jerry just mentioned was some of the trickery that is played by the court system to try to limit minority participation. The Fifth Circuit Court of Appeals, as you know, has the authority in certain cases to render opinions on voting rights matters. And so, for example, even though the United States Supreme Court hasn't said this, because of the issues with who the folks are that live in this area, they have required that when you start looking at the adult population and drawing up a district in Texas, you have to look at citizenship and drawing up the numbers. And I think that's unfair. I think that's not appropriate, but that's because of the large Latino population. But at the same time, the Fifth Circuit says that you can join African Americans and Latinos together if you show that they work together and they have similar concerns and interests, et cetera, in the local community. You can do that. But the courts have been unwilling to. The legislature, for example, applies the issue regarding citizenship, but the legislature disregards the issue regarding whether or not you can create a Section 2 district by joining African Americans and Latinos together. So it's clear cherry picking on their part. And to bring the social dynamic to the forefront, when we looked at the data at the original round of redistricting in the 2011 trial, 49.4% of the Texas adult population from which you draw up districts was African American and Latino combined. If you drop it down and look at the citizenship numbers, the numbers were 39.3. So you can look and see what that number obviously is alarming and frightening to folks who don't want those individuals to vote. So I think that what we've been doing, and we were able to do successfully do in Dallas was we worked with Jerry and Marty and others to have an African American Opportunity District created. What the state tried to do was to create a district to pit African Americans against Latinos. And that's one thing we have to avoid to make sure that the organizations are able and the groups are able to work effectively together like we've always been able to do in the past. But what we're seeking to do up there is to have a second district created because the Latino population numbers justify that. You know, out of all the growth in Texas this last time, 65% of all the growth in Texas was Latino. So how can you draw up 4 new districts and not give the Latino community a new district? But 65% was Latino, 14% was African American, and when you add Asians, Indians, etc., 89% of the growth in Texas was minority. So how is it that you don't give minorities new seats except by intentional discrimination? And so what I would say, the one thing I want to say is besides needing more people to come out and litigate, you know, I'm not a voting rights litigator. I litigate voting rights cases, but these guys are really the experts in doing that. But we need more people to follow suit behind those who are doing this because this is really noble work. And there's nothing, I don't think there's a greater feeling than when you prevail in one of these cases, knowing all the people that you've helped. But we also need people who are even in law school to be part of the activist community and send letters to Congress folks and be part of the engagement because I think we need to tell the United States Congress and others that we really need to fix to Shelby County.
Thank you. Thank you very much. I completely agree. And your comment, and we don't mean to slight the Asian American community here in Texas. We keep talking about blacks and Latinos. Asians face a unique set of problems as well as new voters in this country. I'm reminded of the comment made by former State Representative Betty Brown when she was one of the sponsors of the photo ID bill a few sessions ago before they finally enacted it. And when the witness was testifying in front of her committee about how Asians face these problems with name recognition, she said, well, why don't they just change their names to simple names that we can all understand? That way we don't have to learn Chinese. I thought, you know, there's another gift that keeps on giving from Texas. I was interested to hear Judge Costa, by the way. He said that he was quoting the Texas Constitution of education provisions, and he said something about that it requires the general diffusion of knowledge. I think there's been a little too much diffusion in Texas. But this next person who's going to talk to us has a lot of knowledge. To say that Wendy Davis has been effective is a gross understatement. She was so effective, in fact, in the Senate that they split her district 5 ways in redistricting to make sure that they could try to get rid of her. And her constituents would be the ones taking the blow. But as you all know from having seen her on the national stage, Wendy Davis is one of those bold people who stands up for what's right. And so I'm honored and privileged that Wendy is able to join us today. And Wendy, anxious to hear what you have to say.
Thank you, Jerry. Well, I'm delighted to be here with all these fresh, young, wonderful minds in the room and with these not so fresh but also wonderful minds at the table. I guess based on what Dave Richards said earlier, I am the political ego that was invited to be a witness by Chad and by Jerry, much to their, of course, risk, but it all worked out well so far anyway. Jerry asked me to talk about just kind of the factual side of what happens in a redistricting or voter ID law that's being adopted through the legislature and making sure that as lawmakers, we are helping to create a record that these fine attorneys can then utilize for purposes of showing that there was a discriminatory purpose and effect in the writing of these laws. My district, as Jerry said, was the target of redistricting in 2011. I had won the seat in 2008. It was a seat that had been drawn for a Republican to represent and was represented by a Republican. And against all the odds, we were successful in winning. And I won because I had the support of a coalition of African American and Latino voters in my district, along with like-minded Anglo voters, and actually ran for the seat at the encouragement of members of the minority community in Senate District 10. So when redistricting came around in the 2011 session, I understood that I was likely to be the target of that map drawing process. So at the very outset, I hired Jerry to help me from the very beginning of the session, and my very dear friends at the Lone Star Project, Matt Engel and Lisa Turner. Lisa Turner's here today. They were there to help me on the technical side to make sure that as we went through the legislative session, I was asking the right questions, I was creating the record that needed to be created, and giving an opportunity when we got to trial to demonstrate that there was a discriminatory intent in the drawing of that map. And we were successful in doing that. We made sure that we introduced different alternative maps into the record to show that there was the capacity to build a minority coalition district there, or to at least maintain the one that had been drawn. We actually argued to strengthen it because of the demographic growth in the surrounding area of Senate District 10 in Tarrant County. We made sure through the help of the Lone Star Project to notify people in the community what was going on so that they could give testimony and be a part of the record at the hearings. And then, of course, I did everything I could to create a record of showing that I had asked repeatedly for the protection of the district, that I was being treated differently than other senators were being treated, because after numerous requests to see the maps that were being drawn, I was repeatedly denied the ability as the representative of Senate District 10 to do that, while meanwhile, many of my Senate colleagues were in the back room not only looking at what their maps were going to be, but helping to draw what their maps were going to look like. When we filed our case, Section 5 was still alive, so we filed it under Section 5. It was heard by a 3-judge panel in DC, 2 Republican-appointed judges and 1 Democratic-appointed judge. And I will tell you there was a real low point in that process prior to the court actually hearing the case. The DOJ opines on these cases, either because they bring them themselves or because they weigh in. And in my particular case, when they filed their brief on the Senate map that had been drawn, there was a challenge to the congressional, the Texas House, and the Texas Senate map. Mine was the only district at issue. When they filed their briefing in the Senate map, the DOJ actually opined that Senate District 10 was not protected under Section 5 of the Voting Rights Act. And as you can imagine, that was a heartbreaking day. And they agreed with the state's argument that because my election in 2008 was the first time that a coalition of minority residents had come together to elect the candidate of their choice, it wasn't sufficient to demonstrate that this was a historically protected district under Section 5. It was a devastating blow. And when I talked to Jerry that day, I was sitting in a parking lot about to go in and give a speech to a group of constituents in my Senate district. I thought that all was lost. But the lesson learned there is never, ever, ever give up. And I have to say about Jerry Hebert, there is no give up in this man at all. And he went into the 3-judge panel and argued for our life, literally, to be able to stay in the case and be able to put our trial on along with the evidence that would be put on in the congressional and the Texas House maps. And he was so passionate and so persuasive. The Chief Judge said, "I love seeing emotion in my court," and she let us live to see another day. And we were able, because of the fine record that had been built through the counsel that Jerry gave me through that legislative session and the work that Lone Star Project did, we were able to demonstrate in a very real and profound way the intentional discrimination that occurred, that purposely carved all of the African American precincts out of Senate District 10 and moved them up into a district that was anchored in Granbury, Texas, of all places, highly Anglo, highly conservative, where they would never have a voice at the ballot box again in electing their senator. And all of the Latino districts in Senate District 10 had been carved out, or precincts had been carved out and put in a district that was anchored in Denton and Flower Mound, again, also highly Anglo, highly conservative. And it was so patently clear when you looked at the map, it really spoke for itself to see the way the district was carved apart, that the evidence, along with the record that we've been able to build, was really overwhelming. And so we succeeded there. And because of that, in 2012, we were able to prove that indeed this was a minority coalition district, because once again, even in the face of President Obama receiving much less of the Anglo vote in that election cycle, I was able to hold on to it thanks to the support of my community, who once again cohesively came together to help to elect me. And then just a brief mention of the voter ID case. I was also in the Texas Senate when that law was passed. Once again, I commiserated with some of the fine folks here at the table about the items that we needed to place in the record. And we did that through introducing ameliorative amendments, knowing all along that none of them was going to be adopted, but building the record of showing that each of them was systematically declined. These were meant, of course, to make sure that there was less and less of an impact on minority citizens in Texas. And each time these amendments were introduced, they were denied without the Republicans building any sort of a record of their own about legitimate purposes or reasons for which they were denying these amendments. And that, I think it's fair to say, was very helpful to Chad and to Jerry thus far in that trial process, and I hope that record continues to help us hold those decisions up on appeal. Clearly, these issues are tremendously important. They're as important as anything that a legislature does, if not more, because against the backdrop of what happens in these cases is everything else. If people do not have a voice in electing the folks who are going to represent them and to reflect their concerns, the state will be a state that writes laws that is not at all reflective of its community. And that's what we see happening in Texas today. So if you are considering going into this practice yourself, I hope that you see, and I hope that you will feel passionate about the fact that it's some of the most important work you could possibly do as a lawyer, and that though people may not ever know that Jerry Hebert exists, or Gary Bledsoe, or Dave Richards, or our dear friends Marty and Chad here, they may not ever know that these fine folks exist in the world, but they will feel the impact of their work, because they will be able to, through that work, elect representatives who will care about them and their families and the needs and issues that are so very important to all of them. Thanks for having me today.
Thank you. Thank you, Wendy, very much. One of the things that Wendy actually testified in the DC court before the three-judge court, and it was 2 female judges and 1 male judge. And one of the things that I thought was important to bring out to the three-judge court through Wendy's testimony was not only that she was treated differently than the other senators. They would show other senators' maps, and it isn't that they just didn't show Senator Davis maps. She asked, "Can I see my map?" And they said, "Oh, we don't have your map yet." And we were able, through other depositions, to say, "Oh yeah, no, we saw Wendy's district. It was drawn a month before that," or whatever. And then they told her that she didn't have any, that she was not going to be able to be shown her district, and that, you know, when the time came, they would show it to her. And she never got to see her district the entire time. And then, of course, she was very effective at pointing out the minority coalition that had elected her. So we went through all that, and I remember in the closing argument, one of the things that I said was that, and when she testified, she was very specific about, because she had kept all the emails where she said, I'm still interested in seeing my map to the head of the redistricting committee. So we had a lot of evidence that she was persistent about and building this record. And at the very end, I said, you know, in my closing argument, I said, you know what they did to Senator Davis? They patted her on the head and said, go away, little girl. We'll deal with you later. And the two female judges, I think, really that resonated with them. And I said it on purpose. I mean, I wanted them to know that this was a, huh? Yeah. But I mean, it was calculated. But it's one of those things where, you know, those lessons that you learn, you have to really speak to the specifics of what judges you're in front of. Nobody does that better, in my view, than Chad Dunn, who's going to speak to us now. Chad is a lawyer extraordinaire, tries, unlike myself, who specializes in just election and voting rights cases, Chad tries all kinds of cases. He doesn't need any advice from me. I give it to him all the time, notwithstanding that, because I consider myself to be, you know, like a teacher, and I want to bring Chad along. But yet I end up learning from Chad. But one of the things that I always tell my witnesses is, and I actually probably said this to Senator Davis the first time that she and I agreed that I would be her lawyer. I said, don't write if you can speak, don't speak if you can nod, and don't nod if you can help it during the entire legislative session, unless you speak to me first. And if you have clients who really listen to you, like Senator Davis being very effective, she built her record and on her own had so many ideas about how to protect the constituents in her district. You can win these cases, and you can win them, as Dave Richards says, under the 14th and 15th Amendments, because the law is still out there, and it's good. Chad, you are in a two-person firm, and you largely are the one person in your firm that does voting rights cases. So you're almost a solo practitioner in that sense of voting cases, and yet you can't earn a living maybe just doing voting rights cases in Texas, despite the very fertile field out there for voting discrimination. So how do you, so what can you tell students today who are interested in this area?
Well, thank you. I just want to also say I'm honored to be here at this table. I would be thrilled to just carry the briefcase for any of these extraordinary people. And I'm overwhelmed by Mr. Hebert's introduction of me. Jerry, we all have heroes in life. It's extremely rare that we get to meet one. It's even more extremely rare that we get to be friends with one, and it's even more rare that we get to become family with one. That's how I feel about Mr. Hebert. So I want to talk about, as he's asked me to do, how to practice voting rights law and how to get into this kind of work. As you can tell, I'm somewhat young. I was licensed in 2001. I've been doing this work since then. Before I get there, I do want to talk just a little bit about the fertile ground, as Mr. Hebert references. Jerry and I were happened to be in the Supreme Court chamber when Shelby County was handed down. And we went over there. It could have been Windsor, which is the marriage equality case, was coming out that day, or it could have been Shelby County. We didn't know. But we went over there, and as lawyers in the bar, you get to skip a lot of lines. We waited and waited, and sure enough, they came out. And Chief Justice Roberts, or the clerk, announces it's going to be Shelby County versus Holder. And Chief Justice Roberts has assigned the opinion. And you heard all the oxygen just deflate out of the room. And Justice Roberts read an excerpt of the opinion, and I'm certain that I saw teary eyes in Justice Sotomayor, Justice Kagan, and we looked around the room, and people a lot older than I, a lot older than Mr. Hebert, who had fought these battles, maybe at the Pettus Bridge, maybe in some other places, are weeping. They're watching 50 years of progress go down the drain because 5 judges saw it that way. We went out from the courthouse at that point, and there's of course a media scrum, and we get in a cab, and one of us says, you realize Greg Abbott's going to enforce the photo ID law, because we had successfully stopped that under Section 5. And we both looked down at our phones, and sure enough, the newspapers are reporting that Greg Abbott's gone out and announced that the photo ID law, despite the finding of intentional discrimination by a federal court, will go into effect immediately. And it was such a deflating experience. I mean, we had put so much time and money into trying this lawsuit, time away from, I got small kids, time away from family, time away from spouse, and thinking that you're accomplishing something, and then right there it's gone. And it was hard to pick up. And one of the things you have to have in this kind of work is you've got to have a backbone made of steel. And if you don't have one of those, which I'm afraid I don't, I think Jerry walks around with one, but you got to be able to make one on demand. You got to be able to fake it. And we went and sat down in a hotel room that night and started talking about, okay, well, we're going to get right back up again. We're not going to quit, because that's not what we do. And so we're going to find a new place to file this lawsuit. We're going to file this lawsuit. We're going to find the money somehow. We're going to find the experts again. We're going to do it. And we did. The next day we filed in Corpus Christi in September last year. We tried the case. So what do you do to get ready for a career in voting rights? Well, it seems to me that there's about 3 paths one can take if they want to do voting work. One is you can work in the various nonprofit entities like the NAACP or MALDEF or LULAC and the Brennan Center, other groups around the country. And you can become an expert in your particular field. You can become written in that, maybe perhaps do some research and work on cases there. And that's critically important. People who can devote nothing but their time to voting cases is critically important. Another thing you can do is work for decision makers, work for legislators, work for executives, work for county commissioners. Don't overlook the local officials. They're drawing maps too. They're doing bad things to the minority community also. You can work for these folks, advise them, and be in the process of drawing maps. And another process you can do is go and learn how to be a tool, how to be an instrument. And that's the path I tried to take. And I recently, my son's gotten interested in baseball, so which to me is like magic, because if you throw a ball near me, I'm going to drop it. I can't throw it, I can't hit it. And he goes out there and he hits this ball, and I think, wow, it's just the most amazing thing I've ever seen. And so I start taking him as a baseball coach. And I think my son's, everybody thinks their kids are just the best. I think my son's the best, what has he got to learn from this coach? But we'll come in here and we'll figure this out. And so the coach says, put the ball down, we don't need a ball. And we spent a whole hour about where to put his feet, and where to put his hand on the bat, and where to put his hip. And the coach talked about fundamentals. And every coach who's ever had has talked about fundamentals. You don't play the game, you learn the fundamentals. Well, as lawyers, what we have to do to learn the fundamentals is how to deal with a witness, how to deal with a hostile witness, how to deal with a friendly witness, how to prepare a witness, how to deal with a judge that hates our guts, how to deal with a judge who's never going to rule for us, but we know we got to get past this point to get to the next place, how to deal with all the documents. These are fundamental skills we got to know. And unfortunately, the legal field today doesn't prepare lawyers very well because we have what's called the vanishing trial, the vanishing jury trial, the vanishing trial. It's extremely difficult to get to trial. And I knew that when I became licensed. And I said, well, I think if I'm going to be good at anything with a law license, I can tell you it's not going to be writing briefs. So I better figure out something other than that. And everybody says, well, you make a lot of noise. I said, well, okay, maybe I can make some noise in a courtroom. So I decided I'm going to go try every kind of lawsuit I can get my hands on. And of course, nobody wants to hire a lawyer who just got a law license. And so what I found is, and this is the best piece of advice I could try to give, what I found is that you can gain the experience you need to be very good at this work by doing other work. For example, in Texas, you're entitled to a jury trial for a parking ticket. You're entitled to a jury trial for a speeding ticket. You walk down to the municipal court, and there'll be, at any given day, 5,000 people there without lawyers who would be thrilled to get a jury trial over their parking ticket, who are almost certainly never going to win. So you can walk down the hallway and say, oh, what's your ticket for? Well, I got a speeding ticket for this. Well, would you like a jury trial? I'll try it for you for free this afternoon. And before you know it, you're doing an opening statement, you're doing voir dire, you're picking a jury, you're cross-examining a police officer, which is not easy. You're putting somebody on the witness stand you met that morning. So that's a way to get experience. There are lawyers out there that have cases that they can't get to try, but they can't get rid of it if it's not tried. You call them up and say, hey, can I come in there and carry your briefcase? Or better yet, I'll go try that case for you. I'll go try that car wreck case. There's a lawyer here in Austin who I think is one of the best trial lawyers in the state. His name is Dickie Grigg, and he's got a saying that the hardest cases to try are a sore back case. And what he means is with somebody's neck fusion or something in their back. And he's right in a lot of ways here in Texas because jurors and judges don't take those cases seriously. And that is very analogous to voting rights cases in the South. So many of the judges that we experience when we deal with juries, so many of those folks are desensitized to it. A lot of them have their heart in the right place. One of the things that came up in the redistricting case is we put that evidence on before 3 judges in Washington, and we put that evidence on before 3 judges in Texas. And all these are good people. But evidence would come up, the judges in Washington who weren't born and raised in the South would gasp, hearing that all the female legislators were excluded from a discussion. You know, the judges in the South would say, oh, well, that sounds about right. That's what we do. The judges in the Northeast are thinking, oh my God, who tolerates that? You know, and other like evidence. So you got to realize that you've got a difficult audience, and in a lot of cases, you're playing for a future, you know, a future case. So when Shelby County came down, there was tremendous change in Texas. Overnight, not just the photo ID case, a school board in Beaumont, Texas that had been controlled by the African American community, it was majority African American, was ultimately taken over and is now controlled by a majority white school board. Black city council members in Jasper were removed in an at-large election, even though they were districted offices. A state court ruled that they could be subject to a recall district-wide. So a group of white folks got together and removed 2 black officers. City of Pasadena now has gone to split at-large and single-member district elections, which means a district that's slightly more than 50% Latino, a little less than that percentage in terms of registered Latino voters, is nevertheless going to be controlled by a majority white people. Galveston County immediately went to eliminating black and Hispanic justice of the peace and constable districts. So the walls are bleeding in the state, and it needs foot soldiers, and it needs people who are willing to speak up and say what is not popular anymore, because so many people in the South think we've solved this problem. This problem's resolved. You know, we did that. We had that battle. You know, the bad thing happened at the bridge, and there were changes, and Johnson signed a law, and you know, everything worked great. But that's not the case anymore. So if the one piece of advice I could give is to learn the fundamentals, and I'll tell this last story and hand it back to Mr. Hebert. So I had sued a school or a government agency for adopting discriminatory districts. And I go into trial, and as in so many of the cases that you do, you know, when you're in photo ID, there's a bunch of lawyers on all sides, and you get all these people interested. You're in redistricting, there's a bunch of lawyers on all sides. But you go do some of these smaller cases, a lot of times it's just you. In my case, it was me, and my partner was there that day. And I just start seeing the other side's lawyers come in, and they've all got these little cases on wheels with their names and stenciled into it, and they're setting up their desks, and they've got minions bringing them water, and can I get you coffee? And I'm sitting over here. This is a true story. I'm sitting over here watching this. My phone vibrates. So I look down at it, and my wife says, my wife Shay, who's here today, she says, well, how's it going? And I said, well, I got to tell you, I'm pretty scared to death. There's like 14 of these people. It's like watching a circus, watching all the animals. And she says, well, in a few minutes, they're going to be the ones that are scared. And so having a spouse like that is you know, you can't have anything to replace that. But the other thing, though, that gives you the backbone that you need to manufacture is the fundamentals. You know, when you sit down and take the deposition of the Speaker of the House, which I did here in Texas a year ago, that's an intimidating experience. He's a smart guy. He certainly doesn't want to help me out. And I'm sitting in the State Attorney General's office. There's DPS officers down the hall, and just about everybody in the room would like to see me jailed if given the chance. But I'm going to go in there, and I'm going to take this deposition. The reason I can have confidence in it is because I've done it a bunch of times before. And I may not run into somebody that's got, I may run into somebody that's got a lot of experience, but I know I'm not going to run into somebody that's got so much more experience, I'm not going to know what I'm doing. So it's that kind of confidence that you can build for yourself. And it's that kind of confidence that's absolutely critical in cases like this when you're standing up and there's TV trucks outside. The photo ID case, I would say any given day there were 70, 80 people in the gallery watching. You got probably 40 lawyers in there. Sometimes you have one, you have 3 federal judges. You stand up to that lonely podium and you got a witness. Sometimes you got a spectacular one like Senator Davis. Sometimes you got one who's rather cut your throat. And it's game on. And you walk up there with that steel backbone knowing I've been here before and I'm going to own this courtroom. And when you have that kind of attitude, which you can only develop from experience, you can have some success. Now with us, it's 2 steps forward, 1 step back, but that's all we can hope for in this kind of work. So anyway, hopefully that answers the question, Mr. Hebert. Thanks for having me.
It does, it does. Chad talks about owning the courtroom. I always like to tell people that I am trying to help along in their legal profession that when you try cases, you want to act like you don't own the restaurant, but you're the head waiter. You kind of know where everything is, you know where, and you talk to court personnel and you find out, what the judge's length of time for recesses are, little things like that. There's nothing to the race but the finish. There's nothing to trials except the preparation. Now, on your careers, Caroline Fredrickson and I at ACS and Campaign Legal Center, we joined forces a couple of years ago to create something called the Voting Rights Institute. And it is to train, my wife, Victoria, who's here, looked at Dave Richards and myself, and she said, you need to get another generation of lawyers doing these cases, because you're not going to be around for the next round of redistricting. And I said, yes, we are. We'll see about that. But, so the Voting Rights Institute is up and running. We're going to have a website later this year. It's going to be nationwide. It's going to try to facilitate and help law students who want to transition or who are looking for clerkships but who are interested in helping, or maybe you're in a firm and you want to handle a voting rights matter. And they don't have to be the photo ID case where you need $500,000 in order to do the case. It might be a letter that you have to write on behalf of some constituents to somebody that says, I represent this group. There's a problem with, recalling people at large when they were elected from districts. A whole range of things. So that's one thing that's going to be out there. So, you could see me to get more information. The other thing is, this is personal, I am still looking for, if you don't have plans this summer, I'm still looking for one more summer intern, legal intern, at the Campaign Legal Center in DC. It's usually law schools provide a stipend, and because we don't pay because we get so many applications. And this year I got a lot of applications and I talked to a lot of students, but I didn't quite get all of the students that I thought would be a good fit. So I still have one vacancy left, and if you're interested and want to come to DC and you can afford to get a stipend from your law school, we would love to have you. We're flexible on start and end dates. We don't expect you to take your final exam in May in the morning and come work for me at noontime. You actually are going to, we'll work with you. So that's on a personal note. We do have time for questions. If you have any. We'll see one right here, this gentleman right here, fourth row.
Hi, my name is Nem. Hi, my name is Namdi Okoli-Sewell from GW. Oh, with the camera. Okay, cool. My name is Namdi Okoli-Sewell from GW. So I actually vote in Plano. For the first election that I voted in person. For the last two, it's been by mail. So for certain people, I've had to vote by mail. But I noticed going both ways about it that it's been just so significantly easier to vote by mail in Texas than in person. And I'm wondering, at least for, let's say, people like me who would not generally be the ideal person to vote by mail, the most common person to vote by mail, how may people be able to take advantage of that, or take advantage of so there is obviously a harder way and an easier way, and just how can we spread the easier way?
So I'll start on that one, and Chad or someone else can follow up. But with respect to voting by mail, one of the answers the state had to the lawsuit that we filed is, okay, so we have witnesses who we put on who say, I'm a registered voter, I'm a veteran from World War II, I've been voting since the 1940s in Texas, but I don't have an ID, I'm 88 years old, I don't drive anymore, so I don't need a driver's license, so I don't have an ID. And when I go down to cash a check or something like that, I use my Medicare card or, whatever, and I never have any problems. And the state's response to that was, well, they can still vote by mail. But many of the witnesses said, well, I want to have the same privileges that everybody else has. I want to be able to vote in person. And I think that I've earned that right to be able to vote in person, and I shouldn't have to vote by mail, because I'm not even sure that when I vote by mail, my ballot ever gets received. I don't know whether it gets counted. I never see it get put in the box. I don't have a record of it. And so there was a lot of testimony from people to that effect. And it's particularly elderly people who feel that they've earned, particularly minority citizens, that they've earned the right to vote in person.
I was just going to add to that. So we had a client that we represented in this case. His name was Floyd Carrier, and he showed up. He's in a wheelchair. He fought in the Korean War, and he lives in China, Texas, which is right outside of Beaumont. And he's a war veteran. So this guy is an all-American hero. He happens to be African American, and he's living at home by himself. His wife passed away from a stroke a while back, and he would get his mail by riding his tractor down to the mail station and one of those big silver boxes, mailboxes. He can't drive anymore. He can't have a driver's license, so he drives his tractor. And the people in the neighborhood were scared to death. I mean, anytime he'd get on his tractor, people were locking doors, and Mr. Carrier's out in his tractor. So they made him stop riding his tractor. So he can only get his mail once a week when people drive him down there. So he goes down and tries to get an ID, and I won't go through the whole story, but after spending about $70, he's unable to get an ID, and he comes and testifies in our case that he didn't get an ID. He goes down to vote, November 2013, and he sits there, and he comes up to the window, and since he's handicapped, he's entitled to vote from his car. The poll worker comes out, and she says, "Oh, hey, Mr. Carrier, how are you doing?" And he says, "Oh, I'm fine, I'm here to vote." And she says, "Well, you know, Mr. Carrier, I'm going to need to see an ID." And he says, "Well, I don't have one of those." And she says, "Oh, well, I obviously know who you are, and everybody else knows who you are. You've been voting here for 40 years, but I can't let you vote." And so the state asked him in his deposition, "Why don't you just vote by mail?" And he tells them this story about, "Well, I'm not allowed to drive my tractor anymore, and so I can only get down to my mailbox once a week, and half the time my mail's been taken or I didn't get it, and so I don't feel like I can vote that way. And on top of that, I want to wait until election day after I've heard everybody's arguments, and then I want to go down and vote. I don't understand why I got to vote before everybody else does." And testimony like that was very powerful in convincing the federal judge that, you know, separate but equal is not okay in voting either. So
Let me add one thing to that too, Les. There has been some problems with absentee voting. There's one county that was requiring identifications to get an absentee ballot. And so that's way out of line. Plus there's at least one other county where vigilante groups get the list of names of persons who vote absentee, and they descend on the individual at home and start trying to pry into who helped them vote, what's the basis for. So the clerk up in Bowie County was apparently sharing information with people. So one needs to make sure that they vote in the right way when you vote absentee. I know Jerry tried a case out there some years ago where they were under the new law where they were indicted, I guess, for Councilwoman rape or something related to that. And so if you have the basis for voting absentee, then do it, but just don't do it as a strategy, I would say. Just look at how extreme some of the local authorities are.
And I would add one thing. Marty, you're going to add something too, but one of the points, and I probably should have said this earlier, it's very difficult, especially if you're looking long-term and you know you're going to the Supreme Court, to believe that you're going to prevail on a racial claim in front of this Supreme Court. So you want to come up with maybe non-racial equal protection challenges. You want to be able to show that there's different treatment by election officials for how to administer the Photo ID Act without regard to race at all. The fact that they allowed Rudy Barber to get an ID, for example, without showing the documentation, whereas somebody else has documentation and still can't get the ID, and you can kind of show that differential treatment. Yeah, it's a Bush v. Gore type equal protection, non-racial equal protection claim. But the other thing that you should keep in mind is that on these equal protection challenges, I mean, with early voting, if there was a law that was passed that said Democrats have to vote on Monday and Republicans can vote on Tuesday on Election Day, that's unconstitutional. There's no rational basis for such a disparate treatment, and it would fail under the 14th Amendment. So those are the kinds of non-racial, outside-the-box theories that I think we really have to come up with. Marty, go ahead.
And the final thing I would say about mail ballots is that the legislature has actually made it harder to do mail ballots. You can only witness one, you can only assist one. It's got a severe penalty associated with that. And so it's actually much more difficult than it was before 2013 to do mail ballots. And so as easy as it was for you, it's very hard for lots of folks. So, yeah.
Right.
Yeah.
Another question. Right here on the other side, there's a young man here, and then there's a young lady 2 rows behind him.
Hi there, I'm Nick Warshaw from UCLA. Mr. Richards alluded to sort of litigation strategy from the 14th Amendment, but after Shelby County came down, both the President and the Attorney General sort of proposed, well, they said we might have administrative solutions that can come down the pipeline. And I'm just curious if there was any progress from the Justice Department or from anyone else from an administrative perspective that can sort of rectify the damage the court did.
The only thing that's really, it's a double-edged sword, because if the administration, if the President Obama and Eric Holder came out with a new Voting Rights Act and sent it up to Congress, it would be DOA, right? So that's not going anywhere. So I think the strategy was to keep them out of it. There isn't really much that can be done administratively by the Attorney General at this point. The administrative process that can ensue is perhaps to try to come up with a new voting rights bill that lets the Justice Department focus on current conditions, to maybe look and see which jurisdictions should be covered and make determinations about, how many cases have been lost in the last 15 years in this jurisdiction, and if they've lost 2 or more, maybe they should be covered under the pre-clearance provisions. So there's things like that in the works, but there really wasn't anything administratively I think that could be done. One of the fallouts from Shelby, by the way, is that the Attorney General apparently can no longer send federal poll watchers into jurisdictions. And that was kind of one of those things that was very useful in gathering evidence about what was going on in the poll. Back there, yes, you have, right next to you, yes.
Hi, thanks so much. I'm Paige, I'm 1L at UT. Thanks all of you so much for being here. My question is piggybacking. We really are lacking a lot of political will nationally and especially in Texas. And it seems like we have a chicken and an egg problem, voting rights, we keep losing 5-4. Texas ledge continue to get more and more conservative, and I'm just wondering, in the face of all of that, how do we be optimistic, and what kind of fights can we do and continue to do to move forward?
If you were my age and had grown up when Alan Shivers was governor, who's got his portrait out here, and called out the Texas Rangers to stop desegregation in a school in Mansfield, Texas, you would realize there's reason to be optimistic. It takes a while, but that's not going to happen anymore. At least we know that. When the 1957 legislature was in session, they proposed the whole racial package. This is that followed after Brown v. Board. I mean, the NAACP, they would have banned any member of the NAACP from public employment, for example. And that was just one of the many things. That legislation passed the Texas House 145-5. So it couldn't quite do that today, I expect. So there is optimism out there.
And I'll even strike hopefully even more optimistic note, because one of the things that you should know is that, first of all, things aren't as bad elsewhere as they seem to be in Texas. There's a lot of... but I'm going to get more optimistic. Give me a second. We do find, though, that not only given the demographic changes that are taking place in Texas, I mean, the reason that Republicans who control the legislature engage in the discriminatory redistricting and the photo ID is because that's the only way they can hang on to power unless they're going to change their policy positions, which it doesn't look like they're going to do. So that's why you see a lot of this. But in the states, we do see in the other states, legislators, where that's really, I think, where we can make progress, is at the state and local level, as Chad says. Don't overlook the local level. Because there are a lot of people of goodwill who aren't poisoned by the partisanship you see in the state legislature. And so I do think we can make a lot of progress at the local level. One of the things that I often found bizarre was that the Supreme Court Citizens United case said, corporations have the right under the First Amendment to spend unlimited amounts of money to buy or influence my vote in elections. And they have a fundamental right, First Amendment right. And strict scrutiny applies if we try to restrict corporate rights. Well, why is their right to spend money to buy my vote worth more than my vote under the First Amendment? So we inserted a First Amendment claim in the photo ID case, and the judge found that First Amendment rights of voters were violated. First case I'm aware of that says so. Thinking outside the box, maybe coming up with non-racial theories, and focusing on the state and local level where I think people are willing to see. Even in the fracking in Texas, look at local counties are adopting it, and now Greg Abbott's saying, we don't like local control, right? He wants to have it state control. Kind of the opposite view he took when he took on the federal government. I get up every morning, I sue President Obama, and then I go home. Because of states' rights. Well, what about local rights? So I think that's where the rubber meets the road. Yes. One more question? Do we have time? We have 1 minute? Okay, we can take this one here, and then the gentleman in the, I'm not going to say burnt orange sweater.
Hi, I'm Ann. I'm a 2L at UT. And last summer, I attended the hearings at the U.S. Senate for the Voting Rights Amendment Act. And one of the things I was struck by was rhetoric from some of the senators, including the senators from Texas, about how the provisions of the act were a form of discrimination by northern states against their southern counterparts. And certainly, you know, the provisions weren't technically regional. They had to do with current conditions in recent history. And I was wondering to what extent that sort of rhetoric is prevalent, and if it has an effect on the way that we have to navigate nationally with regard to this issue.
Yeah, I mean, that's a very good question, and that's the real problem with trying to come up with a coverage formula today, because you basically, any coverage formula that Congress were to adopt and say these jurisdictions are going to be the ones subject to preclearance, and you try to say it's current conditions, well, nobody from that state's going to vote to put their own state under the preclearance provisions. There is, however, a provision of the Voting Rights Act that's still intact, Section 3C, that says that if you prove that a jurisdiction intentionally discriminated with respect to voting one time, the court has the discretion to order them to undergo preclearance. So in the photo ID case, we have such a request, and the court did find purpose. We didn't get to the remedy stage because the state took an appeal and got a stay from the Fifth Circuit. But we're arguing the merits of that case in late April of this year, and hopefully we'll prevail, and we'll get 3C relief. In the redistricting case, where we also have evidence of intent, we hope the federal court in San Antonio will find that intent evidence. We think it's overwhelmingly there, and that they will order preclearance relief. I think that's the much better chance we have of getting it. Gentleman in the back.
Hi, Joshua Smith. I'm a 2L at Rutgers. You actually burst my bubble because I was going to ask about 3C. But
I'm very prescient after 45 years.
Well, there you go. But as you rightly pointed out, you do have to prove intent to bail in to preclearance under 3C. That's a really high standard. So if you could elaborate a little more, what do you think the viability long-term of relying on 3C is as a strategy?
Well, first of all, it's extremely costly. The way you prove intent in discrimination cases is you follow the factors set out in a case called Village of Arlington Heights versus Metropolitan Housing Authority. And what they do there is Justice Powell, in his opinion, lists the factors. And, you know, it's like, what is the effect of the law? If it's discriminatory in its impact, that's a good, useful starting point about whether it's discriminatory in its intent. What were the sequence of events that led up to the law you're challenging, the photo ID law? Well, the sequence of events, thanks to Senator Davis, is you had a lot of unexplained defeats of amendments that would have been ameliorative. Did they deviate from the norm and things like that? So you've got a lot of factors that you can put in. Long-term strategy, though, that's going to be on a case-by-case basis. Judges don't like to label a jurisdiction necessarily to be a discriminator because you're basically calling somebody a racist. That's why Section 2 was amended in the first place in 1982 to take out the intent standard and overrule Mobile versus Bolden. But I do think that if you can go after emails of legislators and county officials and city officials, you will find either smoking guns that are enough to establish intent, and I'll just close with this last example. In the redistricting case, we had an email that we discovered after the state fought us on legislative privilege, and there's an issue that's really critical that you'll see. The states will always try to block your evidence discovery on the basis of legislative privilege. But we got an email among the map drawers that was, the subject was the nudge factor. And we thought, what's that? So we looked and it said, this was an email to the map drawer saying, when we draw the districts, remind me to go through with you how we want to draw the Latino districts and the black districts because I want you to employ the nudge factor. And the email response was, I don't know what the nudge factor is, you're going to have to explain. And he said, okay, well, here's what it is. We want you to go into the Latino district that's right now electing a Latino candidate of choice, and we want you to pull out the top 10 Latino precincts that are turning out voters the highest, the Latino voters the highest. And we want to replace those with 10 identical precincts in their composition of Latinos, but have lower turnout of Latinos. So the VAP and the citizen VAP Latino numbers, the voting age population will look the same. The district will look like it doesn't change overall in its Latino population, but the actual turnout will weaken the district and Latinos will not be able to elect, and we can elect an Anglo-Republican. They didn't just say a Republican. So we thought that was if that wasn't a smoking gun, it was a Perry Mason moment as far as we were concerned. I want to first of all just thank again ACS. Thank you all for coming and being a part of this event. Thank you much.